for hey guys. Thank y'all for coming. I know most of y'all. For those I don't, I'm Paul Watkins. I'm one of your city attorneys. Our speaker today is Chris Graham from the Mississippi Ethics Commission. Chris is here because we asked him to come kind of give y'all a rundown of the state's ethics laws, open records laws, or public records laws, and open meetings laws. These are questions that we get quite a lot between our board and commission members, and I see some of y'all here today, and just general day-to-day stuff. Some of this is going to be pretty intuitive, but the reason Chris is here is because some of it is not. And it's good to have kind of a background. A lot of this you'll see is more complex than you think it is, and if nothing else, we wanted to give you all the opportunity to get kind of a primer. Myself and my partner, Pope Millette, go through a training like this about once or twice a year at our Municipal Attorneys Association meeting. It's always very helpful. There's always something that you forget about or you don't remember. And hopefully by the end of it, if nothing else, those of you who have been on the wrong end of one of my lengthy lectures will understand that I wasn't just making it up at the end of the day. This is basically personal vindication for me and not much else. So with that, thank you, Chris. We appreciate you being here.
How many city employees do we have here? All right, the rest of y'all board members or something, commission or board member? Do we have any elected folks in this group? All right, so some of the aldermen came this morning and the mayor came this morning. I'm Chris Graham. I work for the Mississippi Ethics Commission, and my goal here today is just to give you a little bit of information. Professor Bradley's been banned from asking any questions during the presentation.
We're going to do that during Planning Commission.
Yeah, that's right. I went to law school here at Ole Miss, and Professor Bradley taught my contracts class and corporations. I think I took with Professor Bradley. He stained those topics into my brain, I think, forever. But glad to see Professor Bradley. I'm going to spend probably an hour and a half, maybe 2 hours, going through things. I got a little bit of feedback from the earlier session, and I'm told that I need to just lay it out for you guys. If you violate any of these laws that I'm going to talk about today, the Ethics Commission will come get you and do bad things to you. So we're not going to spend a lot of time talking about the penalties, and I'll try to roll on through those. To tell you a little bit about who we are, we're the Mississippi Ethics Commission. It's a state agency. We have 3 primary areas of jurisdiction that I wanted to talk with you guys about today. We're a state commission. I have a board, an 8-member board that we answer to. I'm the assistant director. We have an executive director, and we have 4 other employees. 2 of our board members are appointed by the governor. 2 of our board members are appointed by the lieutenant governor. 2 of our board members are appointed by the Speaker of the House, and then 2 of our board members are appointed by the Chief Justice of the Supreme Court. So we have a pretty wide range of appointing folks. Our commission votes on everything that comes before our commission. The staff prepares recommendations, gets cases ready, but everything that gets done by the Ethics Commission, it takes 5 members of our commission to vote yes to get anything done. So we are a state board, very small state agency. Our budget probably wouldn't cover a quarter of the Parks and Rec budget for the city of Oxford. We have like a $600,000-700,000 budget, real small agency. And our primary areas of jurisdiction are enforcing the ethics and government law. I'll talk a little bit about what that means. We also have a role under the Public Records Act and the Open Meetings Act. We'll try to get to all 3 of those today. The ethics and government law, we do 3 things related to the ethics laws. Anybody here ever heard of an Attorney General's opinion? All right, advisory opinions issued by the Ethics Commission are not AG opinions. They're similar, though. We only issue opinions on the ethics laws. And the way that works is if a public servant believes that they might have an ethics issue, which we'll talk about what the ethics laws say in a little while, they can write into the commission. The commission can then issue an opinion to the public servant about their situation. And if you follow that opinion, you have some immunity under the law. So basically, before you get yourself in an ethics problem, you can write in and ask, hey, what do I need to do? And the Ethics Commission can give you advice. If you follow that advice, you have immunity under the ethics law. Okay? I was asked earlier in the earlier session, well, what if the person doesn't give you all the facts in their request? And the only real problem we ever have with these opinions is somebody leaves out a really important fact. And of course, if you leave out a fact that's important to your situation, you wouldn't have any immunity because you didn't give all the facts. The second thing we do The second thing we do is we enforce the ethics laws. If somebody thinks you violated the ethics law, they can file a complaint with the Ethics Commission. We then investigate that complaint, and then we can actually enforce the law against you, which would include ordering you to repay any money that's been illegally paid, possibly. And then also, the commission can impose a penalty up to $10,000 per ethics violation. So we give out advice, we enforce the ethics laws. Third thing we do is we maintain statements of economic interest. Since none of y'all are elected folks, y'all don't have to file any kind of statement with us. That's limited in the city. That's limited to your elected folks. But we have statements of economic interest that your city leaders have filed. They're electronically available on our website. We're required. We're the agency that they have to file those with. I'm going to jump forward just a little bit. Like I said earlier, if you violate the ethics laws, you can potentially have to repay any money that was illegally paid. You can have to pay up to a $10,000 fine. The commission actually holds its own hearings, so if you have an ethics case, you might have to come up here in front of the commission and be questioned and under oath. It's an administrative process, and then you have some appeal rights to take your appeal to the Hinds County Circuit Court. The reason I started out with the hearing and penalties, a lot of people don't understand how significant a violation of the ethics law can become. And to give y'all a real quick example, some years ago, the Ethics Commission had a case against Dr. Clyde Muse, who was the president for Hinds Community College down in the Jackson metro area. And the community college law at that point required that the community college president make a recommendation of all hires of staff for the community college. And Dr. Muse's wife, for years, had worked with the community college. She was a very well-known educator, and by all accounts, she was a very effective educator. The problem is, all those years, Dr. Muse was required to make the recommendation to his board, the community college board, that they hire his wife. And we'll see in a second, one of the ethics laws says you can't use your official position to benefit your spouse. So every year that Dr. Muse recommended that the board hire his wife, and they did rehires, I believe, every year, he violated the ethics laws. And what the Supreme Court said when that case finally made it to the Supreme Court is that the damage to the public trust is what the ethics laws exist to protect. And even though Dr. Muse was not doing anything morally wrong, his spouse was a very good teacher, had provided a really good service to the college for years. He violated the ethics laws every time he recommended that she be hired. And so each one of those recommendations was a violation, and the Supreme Court held that for a number of those violations, he had to repay the entirety of her salary that was unlawfully paid, and that they didn't get any credit for what amount of time she spent actually teaching the courses or what good value that the college got. And the reason that the Supreme Court said that you don't get credit for that stuff is it's the damage to the public trust that we're trying to protect. We're not looking to see whether or not the college got a good benefit. And so the ethics laws exist, and most of the time, almost every time, whatever good to the government comes out of your ethics violation, it's irrelevant in determining whether or not you violated the ethics laws. And so the ethics laws are really a little bit misnamed. They probably ought to be called the conflict of interest rules, because ethics automatically makes you infer that there's some morally bankrupt problem with what you've done. And what you'll find here is sometimes you can violate the law and it can be really bad, but sometimes you can violate the law and you haven't done anything to hurt the government. And so what we know about the ethics laws, it exists so the public can trust that you don't have your own interests in mind when you're taking actions on behalf of the government. Yes, ma'am.
Why does the appeal go to Hinds County? Is that part of the law?
The legislature wrote that into the law. Before 2008, when the Ethics Commission had cases, we didn't have any ability to hold hearings. We had the ability to go investigate a case, and if we wanted to proceed forward in a case, we had to go file a lawsuit in the circuit court wherever the defendant resided. And in 2008, the legislature changed that and put in an administrative process. So now, if you have an ethics complaint filed against you after the commission has finished investigating it, the commission is the entity that holds the hearing, determines the facts, and then imposes the penalty, and then it's appealed to the Hinds County Circuit Court It's pretty common for appeals from state agencies to go to Hinds County because that's where the state government, most state government offices are located. And I believe that's why they ended up making it the Hinds County Circuit Court. It was pretty, as an aside, it was a little difficult sometimes. For example, we had a case against the Chancery clerk one time who's elected in the county. And when we walked out of the office, this was back before 2008, when we walked out of the Chancery clerk's office telling him, hey, you've got a problem, this is what you've done, his response to us was, good luck getting a jury to convict me, right? Because I live here and I'm elected here. And you know, one of the practical problems is most of our cases are paper cases. You can go look at the paper and decide. There's usually not a whole lot of facts in dispute in our cases. Either you did something or you didn't do something. And so the jury trial it is not always the most essential thing in an ethics case. So the legislature felt comfortable taking that out of a jury trial setting and putting it in an administrative setting, basically.
Chris, before you move on, I just want to point out for everybody's benefit, if any of y'all ever have an issue that arises that you feel might have an ethical component to it or you're just uneasy with, you can always, of course, contact your supervisor or the mayor or your executive director, whoever your liaison is with the city. But you should always feel free to contact Chris and his staff directly too. I burn up his phone lines constantly, just asking quick questions, and they're really easy to work with, walking you informally through an issue, because as we talk about all these ethics and government law issues, these are issues that are personal to particular people. If there's an ethics issue, generally it is an individual's problem and not a board's problem. So if you have concern that there's an issue that might arise, nothing in the world stops you from picking up the phone and calling down to Jackson, so you don't feel like you got to go through any red tape here in Oxford. And the same goes for requesting a formal advisory opinion. An individual is always welcome to not only call and ask for informal advice, but if you feel like you need a formal opinion to protect yourself against liability from some situation that you foresee arising, you're always welcome to do that. We've helped city employees in the past draft those up and send them down for review and an opinion. But there's no reason you have to go through us or anybody else in the city government to do that.
Yeah, the Ethics Commission exists. You know, I told you guys, we issue, with ethics law issues, we issue advisory opinions. Those are official opinions. Then we investigate complaints for folks who don't seek our opinion and they might mess up. And then, of course, we maintain those statements of economic interest that none of y'all have to file. We spend most of our time talking on the phone and serving as a resource for local government entities. So the ethics law applies to any public servant in the state, except for maybe federal employees and officials. So anybody at the state level who's an appointed, elected employee of the state, and any local government, which is going to, in my mind at least, include school districts, which we have a bunch of those, municipalities, we have a whole bunch of those, counties, and that's going to include your volunteer boards, like your planning commission board members. You're a public servant of the city because you serve on that board. And so the definition of public servant is really broad and it applies to a lot of folks in the state. And we serve, you know, one of our main purposes is to serve as a resource for you guys so that you don't have to go figure out what all these ethics laws say. With relation to public records and open meetings, which I'll cover in a little while, we really just decide cases there. But we do still give out a lot of informal advice and tell folks what we think. So we really exist to serve as a resource for you guys. And I would hope that you all would feel comfortable calling us and asking us questions. We're not like the auditor's office. I always joke with the auditor's office, if you call them, they might show up and investigate you if you call them and ask them a question. We're not like that. One thing I skipped over is how to file a complaint with the Ethics Commission. Complaints in front of the Ethics Commission have to be filed by someone. We don't just show up because somebody is called. So we require the statute that we're governed by requires a sworn complaint signed by somebody under oath. So if we get a telephone call, we're not going to show up and come investigate just because we get a telephone call. Of course, we get lots of hypothetical questions too. I wonder how hypothetical they really are sometimes. So anytime you might have an ethics issue or you think you might have an ethics issue, please give us a call. And of course, you guys have very capable city attorneys here in Oxford, so I would encourage you to call your city attorney as well. Ethics laws, If you look at the ethics laws, there are basically 8 things that you can't do. And I put this slide up just to show you that there are 8 separate hoops that you have to jump through to make sure you're not in violation of the ethics laws. We're going to go through a bunch of those here today. The first is board member contracts. This is actually in section 109 of the Constitution of 1890. It's also in the code, and I've got the site there. And what this section says is if you're a member of a public board, so it only applies to board members, you cannot have a direct or indirect interest in any contract that's authorized by the board. Okay, so if you're a board member, you cannot have a direct or indirect interest in any contract that's authorized by your board during your term of office or within 1 year of you leaving office. Okay? Pretty straightforward. We have a real hard time figuring out what an indirect interest is sometimes. A couple of notes about this section. Like I said, this only applies to members of public boards. Of course, it applies to the legislature as well. A really important thing, and we get questions about this all the time, we'll have a board member call us and say, hey, my board's about to vote on a contract tonight, and I think I want to put in a bid, or maybe they're going to approve an RFP, and I want to be the one that gets the contract. If I just don't vote on this thing coming before my board, if I recuse myself from this thing coming before my board, won't I be okay? And the answer to that question under this section is no. You can't just recuse yourself and then go have an interest in a contract that's authorized by your board. This section says if you're on the board, you can't have an interest in any contract that's authorized by the board. It doesn't matter whether or not you voted on it or voted against it. It's a flat prohibition. You cannot have a direct or indirect interest in the contract. Okay? So recusal will not fix this kind of violation. If you've got a problem under this section because you're a board member, simply not voting on it doesn't fix your problem. Okay? The second question we get, this is usually what we get from supervisors because they're real smart, right? Supervisor will call and say, hey, we're not writing any of this stuff down, so there's no contract here. And Professor Bradley will say, no, that's not really true. You can have an oral contract. Pretty much anything in the ethics and government scenario, anything that involves the payment of money to someone, there's going to be some kind of contract. It's an oral contract, it can be a written contract. For purposes of Section 109, you're going to have a contract in place whether it's written or oral. Okay? So not writing it down doesn't fix any of your problems. The other thing that we get sometimes, well, our board is not actually voting to approve the contract. And what the Supreme Court has told us is that authorizing a contract in the context of Section 109 in this section here includes funding the contract. So if your board appropriates money that goes to fund a contract, your board has approved the contract. So as it relates to the Board of Aldermen, when they approve the budget for the city, they have funded every contract that the city is going to enter. And they can't have a direct or indirect interest in any of those contracts. Okay? So even if they appropriate money and another agency or another department or another board within the city is responsible for finding a vendor and spending the money, it does not matter. The Board of Aldermen appropriated that money to that board, so they've authorized every contract. Same thing with the legislature. We see it with the legislature all the time. The legislature approves all state agencies' appropriation bills. So the legislature has effectively approved every contract every state agency enters into. Okay, so the appropriation of the money is an act that has the effect of authorizing the contract. Payment of a claim on a claims docket would be the same way. If your board approves any kind of payment to a group, that would be the same thing as authorizing the contract. So it's not simply voting on a contract which constitutes authorizing. It's all these other things that could have the effect of authorizing it too. The last thing we get is we'll have a supervisor, because none of you city people are crazy enough to ask this question. Supervisor will say, well, I'll just quit, and then my dirt company can immediately start selling gravel to the county. This prohibition says if you're on the board, you can't have any interest, direct or indirect, in a contract that's authorized by the board during your term or within 1 year of you leaving office. So you can't just simply quit your board and immediately start contracting with your old board. So there is a 1 year prohibition. And again, this section only applies to board members. All you folks who raised your hand earlier and said you're city employees, this section doesn't apply to you. But the rest of the sections that we're going to talk about apply to city employees and board members. Okay? Yes, ma'am.
Can we do it for instance? Can
Yeah.
Maybe do it for
Uh,
instance.
We call that a can-a-man question?
Okay, so I work for Visit Oxford, we're the tourism council.
Yes.
And so by legislation, our council has to have 3 people from the hospitality industry on it.
Yes.
So let's say there's someone from a hotel in town, a restaurant, and another hotel. And we have a group coming in, like we do every other week, and we put them at a hotel. Does it have to be at a hotel that is not owned or in any way associated with someone on the tourism council, and does that apply to the restaurant or?
All right, so we have a tourism commission or council here in Oxford, and they receive money through some special tax, probably,
Through the
and-
lodging
and it
tax
gets
and food and beverage.
funded, and a couple of those individuals are from the industry,
Right.
because it makes sense to have some people who have a vested interest in tourism help you out with your tourism issues. And the question is, if I have a board member who owns a hotel, what'd you say, well,
I
owns,
mean, has an interest in a hotel.
has an interest in a
Or
hotel,
is a hotelier and also has an interest in a restaurant.
okay? So the first thing we look for is, do you have a board member? Yes. Is there gonna be a contract? Yes, right? Is it gonna be authorized by your board? We said authorized can be to vote to pay
So
money,
even if they approve the budget.
yeah. Or they could approve the individual claim when it comes in. Do they vote on the claims docket, or does your executive director just pay the amounts?
The executive committee votes on the bill document.
So a committee of the big board
Right.
votes on the claims docket. Yeah, most likely, they do approve your budget every year? Yeah, most likely that's gonna raise a section 109 issue, and the only issue is gonna be, does your board member have a direct or indirect interest in that payment? And I can tell you, the general rule is, if you own a place, if you own a hotel, you're gonna absolutely have an interest in that payment,
Well,
It-
let's hypothetically,
hypothetically speaking.
in this purely speculative tourism council, hypothetical setting, or would we be talking about a group calls and says, hey, can y'all help us out with a hotel block somewhere in town, and y'all staff say, yeah, we'll get you one, we'll haul over there and set that up.
That or a media tour comes in that we're inviting to Oxford to write about Oxford. We're inviting them to the tour tonight. And
And-
we're gonna put it at a hotel, we will pay out of our budget for
I
a
see.
hotel.
Okay.
Yeah, and it's different, if you are just helping folks get to a hotel, you'd wanna make sure your board member is not involved, because it would be a problem under a different section of the law.
That's more often.
But if your board is actually paying for the bill, you've got a section 109 issue, and usually the big issue in that type scenario is, does your board member have an interest in it? If your board member is a janitor or what do they call the people, the housekeeper? If your board member is a housekeeper at the hotel, that person might not have an interest in that contract. And we spend a lot of time in our office figuring out what is an indirect interest. If you're an owner, it's pretty easy to say you've got an interest in that payment. If you're somebody who's just responsible for cleaning some rooms, it's a little harder to say you automatically have an interest in that transaction. So it can get, factually, it can get real specific as to your situation. But if it's an owner, you've got a section 109 issue, and you gotta be really careful. Now, that wouldn't prevent you all from keeping that hotel on the list when y'all are recommending groups come in and stay somewhere. But that's that comes under a little bit different part of the ethics law. But I think your hypothetical question raises some real potential problems. Okay. Any other questions? Yes, sir.
Chris, on your indirect interest,
Yes, sir.
after you finished the course of corporations, the Model Business Corporation Act was amended,
Yes, sir.
and the most detailed statutory provision I know of about indirect interest is in the Model Business Corporation Act, the provision about conflict of interest.
Yes, sir.
And it's not thought to be a perfect document, but nevertheless, it has quite a lot of detail.
Yes, sir. And we spent a lot of our time trying to figure out what an indirect interest is. And,
repeat the question?
oh, I'm sorry. Professor Bradley was telling me I might want to go look at the Model Business Corporation Act, which was amended after I got out of law school, because there's a pretty detailed explanation about conflicts of interest and indirect interest within the conflict of interest rules. And we do rely on corporate law as it relates to that. The commission very often will try to make a factual determination that a lot of times, unfortunately, is not quite as detailed is probably what's in the act itself. But that probably would be a good resource for us to take a look at. Any other questions?
I'm sorry, can you say the resource one more time?
Model Business Corporations Act, which we've never applied in an opinion. The Ethics Commission's never applied in an opinion. Anything else? Okay. The way this usually works, the commission gives out advice. I told you all, I'll just show you a couple of opinions. This was an opinion by a candidate for alderman, and that candidate's insurance agency served as the agent of record for the city. And the question was, after I get elected, can my insurance agency continue to serve as the agent of record for the city? The answer to that question is no. When you take your position on the board, and anything comes before the board which has the effect of funding or authorizing the agent of record agreement, whether it be payment of the insurance policy or whatever else it is, you would have a Section 109 problem. So your board members can't do business with their board.
Can they still do bonds?
Bonds,
Like for, like development has bonds and insurance agencies do bonds?
yeah, the bonds are a little bit, they're similar to the insurance products, but the bonds get a little bit more complicated. But if they're taking a premium off the bond, then the answer would be no, they can't write those bonds. Does that answer your question?
Yes.
Yeah, it would apply equally to bonds probably, once they take office.
If it's bonds in favor of the premiums being paid by the government.
Government, yeah, that's right.
If you just have a general, but what if, this may or may not be part of what Andrea was saying, but if you have a candidate for alderman who is in an agency that writes bonds for private development,
Yeah,
that may be.
if you change the fact and say it's not like a bonded official with the government, but there's some type of development going on and you need some type of, I don't know if you call that a surety bond or performance bond or whatever. The issue you always step back and say, is there a contract? Is it being authorized by the Board of Aldermen? And most likely the Board of Aldermen aren't going to be taking any, or whatever board you're talking about, aren't going to be taking any action which has the effect of authorizing that particular contract. Now, if they were paying for which you would expect them to, if they were paying for the bond or something like that, you would have a problem. But usually those things are not contingent on the Board of Aldermen doing anything. Now, sometimes you get real complex. Sometimes you can get a project that's contingent on the Board of Aldermen doing something, and you can get, if you have a contract that says it's contingent on the Board of Aldermen doing something, then you can have a Section 109 problem even in the private sector if it's that specific. But generally speaking, private bonds would not be a problem unless the government for some reason paid for it, which I wouldn't expect. Okay? The other big question we get is, do I have an interest in my spouse's income? Right? If I'm an alderman or a member of another board that approves a contract, can my spouse do it? And the Supreme Court has told us you have an indirect interest in your spouse's income. Okay? What follows that is, do I have an interest in my child's income or my children's incomes? And the answer to that is it depends. And it depends on what kind of financial interest you have with your child. So if you have a dependent child who lives in your household and you're a board member, then your child, if you're approving a contract or funding a contract, your child can't have any interest in that contract, is the bottom line. So whether or not your children can do business with your board depends on whether or not you're financially independent from your children. Okay? So spouse probably can't do business with your board. Children may or may not be able to. Any questions? I told a joke earlier. We had a supervisor one time. I like to pick on supervisors. We had a supervisor one time who called us and said, "Hey, I'm trying to get my child on with the county," which probably violates the next section because he was trying to get his child on with the county. Can he work for the county? And we said, "Well, are you financially independent from your child?" And he said, "Well, if he gets this job, I will be." Unfortunately, you have to be financially independent before you get the job. So I know aldermen never get into that situation, right? We don't have any aldermen here, so we can talk about it. But the mayor came back in, though, so we're going to have to be careful talking bad about the board. All right, so we made it past the board member section of the law, and this is a separate section of the law that I just mentioned, the supervisor might have been violated. This section of the law says, if you're a public servant, all right, so it applies to everybody in here. If you're a public servant, you cannot use your official position to obtain or to attempt to obtain a monetary benefit for yourself, your relatives, or any business with which you're associated. Okay? It's real simple. It's three things. You can't use your official position to benefit yourself, your relatives, or any business with which you're associated. Yourself, that basically means you can't steal from the government. You can, if you're paid, if you're an employee of the city, you can go to your boss and say, hey, I need a raise, because it does say you can, it says you can, you can't use your official position to obtain any monetary benefit for yourself other than that compensation provided for by law. So you can go ask for a raise, you can fill out expense forms and ask to be reimbursed expenses. Okay, with relatives, it's a little bit more complicated. Really, it's more straightforward. Law says you can't use your official position to obtain or attempt to obtain a monetary benefit for your relative. And this is what the ethics law defines as your relatives.
Chris, after this morning's meeting, it came up about a bid situation where a spouse had worked, the city was working, and the husband ran a business and would bid and would sometimes bid the low bidder and sometimes not. Does that make any difference?
Yeah, the question is, if I'm a public servant and I'm in a department and my spouse bids on a project of some sort, and my spouse is the low bidder on the project, if I'm the one approving those bids, or if I have any role in grading those bids, or if I have any role in reviewing the work that is done under those bids, any of those things, even if the city is the one who approved the bids, any of those things that are prerequisites to my spouse getting the job, or getting paid under the job, or the city saying my spouse has done his or her job, any of those things would result in a violation of the law if I'm the one who's doing it. So if my spouse is involved, I'm out of the picture. I can't be involved because I cannot use my official position to obtain or attempt to obtain a monetary benefit from my spouse. And a couple of things about this statute that I skipped over. This statute doesn't say you have to misuse your position. My spouse is the low bidder, great deal for the city. My spouse may do the best job for the city. My spouse may be the only one who can do the job for the city. But just like Dr. Muse's wife, I told you about Dr. Muse's case earlier, she provided a good service for the college, and the Supreme Court said it doesn't matter. What matters is the law says you cannot use your official position to obtain a monetary benefit for your spouse. And it doesn't say misuse. If it said misuse, then maybe it would be okay, but the law doesn't say misuse, it just says you can't use your official position. A couple other things. This section is the only section that you can recuse yourself and get out of a violation, okay? So if you've got to use your position to get a monetary benefit for your spouse in order to violate this section, the way you keep from violating this section is you recuse yourself from anything that involves the relatives that are here on this page, okay? And what's a recusal? We get questions all the time, well, what if, and usually from board members, what if I just abstain from voting on the thing that involves my spouse? The Supreme Court has told us if you abstain, then your vote is essentially with the majority. Okay? So if you just abstain, you have voted with the majority, which means you use your position to benefit your relative. Okay? So abstention doesn't keep you out of a violation. What the commission says keeps you out of violation is a recusal. So if you're a board member and something is coming up about one of your relatives, if you're a planning commission member, y'all handle complaints against properties as well as planning? Y'all handle any of that? Y'all handle variances on planning commission? If my brother seeks a variance from the city, he's one of those relatives listed here, sibling. We had to spell it out for supervisor because I didn't know what a sibling was. If my brother applies for a variance for his property, and I'm on the planning commission and I vote on that variance, if that variance is going to result in a monetary benefit to my brother, I've violated the ethics law. Okay? And so the way I would recuse myself from that is before that matter came up before my commission, it's on the agenda before it comes up before the commission, I step out of the room, let the commission handle whatever they're handling related to my brother, and then I come back in after the commission is done, all discussion's done, the vote's done, and it's over. Okay, and then probably the most important thing, hopefully all of your boards are keeping minutes, is when I get the minutes next month, I've got to actually read the minutes, I've got to actually look at them. I know a lot of board members don't like to look at the minutes, and make sure whoever's keeping the minutes has written down that I was out of the room before it came up, and I only came back in afterwards. I can't tell you how many times we go back a year or two later, and you go look at the minutes, which the planning commission member who's in trouble voted to approve, just didn't bother to read, and then you go read the minutes, and it looks like the planning commission member was in the room whenever the vote took place, and nobody can really remember. The planning commissioner said, oh, I'm sure I didn't stay in the room. And the question is, did you vote to approve these minutes? Well, yeah, I did. It was unanimous. The minutes show that I voted yes for my brother's variance. And like I said earlier, I don't know if I said this earlier, most of our cases are paper cases. And so on paper, you have violated the law, and we have to try to figure out, what the truth was. So as a commission member, you want to make sure that your minutes are accurate whenever you recuse yourself.
Does the public staff have the same problem? Does the planning staff have a brother or sister at their company?
Yeah, the question is if it's an employee, the planning commission staff who works for the city, what do they do? Like I said earlier, this section applies to everybody. So if I'm the director of, y'all call him director of community development, what do y'all call it, planning and development? If I'm the planning director and my brother applies for a variance, I've got to recuse myself completely from that whole variance process. It's pretty difficult if you're the director, but you wouldn't want to be involved at all. So any kind of official minutes where it shows I was present, you would want to make sure those minutes say I was not in the room. And then also the commission says you can't do anything behind the scenes, because if we can go through either through emails or testimony that you were behind the scenes talking to your commission members or sending them emails throughout the week on issues related to your brother's variance, then we might be able to prove a violation of the use of office section. So recusal means you're not participating in a meeting, you're not participating in any kind of behind the scenes meeting, you're completely recused from the matter. Okay? Wake up. All right, so those are your relatives for purposes of ethics law. Any question about those? Now, one thing I didn't mention earlier, there's a separate statute, it's called the nepotism law. And it's very similar to the ethics law, but it's not in the ethics law, it's separate from the ethics law. The Ethics Commission does not interpret that section. So if you're working in a city department, or if you're on a city board and you're talking about hiring somebody for a position, you've got to call two governmental entities. One's the Ethics Commission, and then the other is the Office of the Attorney General, because they give out advice on the nepotism law. The nepotism law is fairly similar to the ethics law, but it has some material differences. Okay? But we don't give out advice on the ethics law. We tried to get that taken out of the law back in 2008. We made some revisions to the ethics law, and the thought was to get rid of, repeal, I guess, the nepotism statute, so you just have one agency to call whenever you have questions like this. But the legislature chose not to get rid of those statutes. So when you're talking about hiring a relative, you still got to make two calls. Okay? Any questions about that? A couple of opinions. How does this work in real life? This is an opinion where the commission was trying to give advice to a fire department employee. The firefighter had just got promoted to fire chief, and his child worked in the fire department. And the question was, can I be the fire chief and my child continue to work in the fire department? And what the commission said is eventually, you're going to do something as fire chief which results in monetary benefit to your child. We don't know what it is, and we don't know when it will happen, but eventually it will happen. Usually what we see when we get cases like this is that the fire chief has gone and presented the budget as a department head to the mayor or maybe even the board of aldermen. If the fire chief presents a budget which includes money that's going to be paid to his or her child, that's going to result in a monetary benefit to the child. Sometimes the fire chief will be going in and trying to get raises for all of his employees, including, as a group of the class, the child or any other relative, but this was a child in this opinion. So that would be another thing that would violate the ethics laws. We also see where the fire chief might be signing off on the weekly or monthly payroll sheets, which shows who worked how much they worked, and then maybe has some reconciliation for how many hours they're going to be paid. It's a prerequisite to a child getting paid. And even though the fire chief's signing off on everybody's, the child is in that list, that signature, technically that's a violation of the ethics law. And one thing about the ethics law is it doesn't have a grandfather's clause. There's nothing in the law that says if your child was employed there before you took over as chief, then it's okay. So what the law says is, if you're a public servant, you can't use your official position to get a monetary benefit for your child. And so what the commission has said is, if you're a department head, or if you're in the direct line of supervision of your relative, eventually you're gonna violate the ethics laws. That's not necessarily the case whenever you're talking about employees who are on the same level and there's no supervisory authority. But when you start having supervisory authority over your relatives, there's a real potential you're going to violate the ethics law. It's not an automatic violation. So if we got a complaint, if this was an opinion, and we said due to the potential for a violation of the use of office section, you shouldn't do it. And if we got a case on this, we would actually have to go find an act that had occurred, like signing a payroll sheet or presenting a budget or something. And most every time we can find some action that you've taken that resulted in a monetary benefit to your child. Okay? This is a real tough opinion. We had some grimaces in the first hour over that. Any questions about it before we move on? Yes, sir. Is there any reason why the grandfather clause was not considered? I think the answer to that question is because you have to actually do something under this section. That if you say it's okay to do something if your child was already there, it really defeats the purpose of the law. Although it might would be fair to have some type of grandfather clause. But no, there's just never been a grandfather clause. Sir?
Seems a little harsh.
Very harsh. Yes, sir. Very harsh. The nepotism statute, as an aside, the nepotism statute that I mentioned was a different statute. It actually does have a grandfather clause. But it only pertains to hiring. That statute's limited to hiring. This statute's a little bit broader because it says you can't take any action in your official position which results in a monetary benefit to your relative. It's a tough opinion, it's a tough law. And it doesn't, I mean, this is an area where the law doesn't always make sense. And I can tell you the competing interest is the same thing I said earlier. It's the public knowing that you're looking out for the interest of the government and you're not tempted to look out for your own interest. And what happens on these cases, half the time the relative of the fire chief or whoever it is not getting any special perks. But people do come in and question whether or not the fire chief is giving, or that person's getting better hours, that person's getting favorable treatment. So this section is designed so that the public doesn't question the objectivity of the people making the decisions. It's a tough opinion.
It puts the father in a catch-22 situation.
The comment was it puts the father in a catch-22 situation. It really does. And when you're talking about brothers, you talk about really getting two brothers upset with each other when you say if you get promoted to fire chief, your brother might have to find another job. It's really tough. In small towns, it's that much worse. Yes, sir.
Who makes the call?
Who makes what call?
Who quits?
Who makes the call and who quits? I guess it's whoever has the highest rank. I mean, your options are, if you're the one getting promoted to fire chief, and I think you walked in right after Paul Watkins had said this, if you're the one getting promoted to fire chief, you're going to be the one in violation of the law. So it's going to be up to you to pay the penalty, and it might be up to you to pay back all the salary if it's the type of case that the Clyde Muse case was. So it would be incumbent upon you as the boss to figure out, all right, what am I going to do about this? And so your brother wouldn't be in violation of the law by continuing to work there because he hadn't done anything other than be your brother. But if you're using your position, the person using their position is the one who's going to end up paying the price for the violation. So yeah, it would be personal to the person who's in the supervisory authority. So you might have to pay for it if you didn't decide to move them out. Good question. As an aside too, the law says that contracts that violate this section, which would be here would be talking about an employment contract, are voidable by the city. So there is some potential legal out for the contract. Any questions? Any other questions? All right, so I said earlier you couldn't use your official position to benefit yourself other than compensation provided for by law. You couldn't use your official position to benefit your relatives, and we talked about who your relatives were. And then the third thing is you can't use your official position to benefit a business with which you are associated. And that term is defined in the law as any business where you as a public servant or your relative has any of these positions. Okay? So if you or your relative have any of these positions in a business, you can't use your official position to get a monetary benefit for that business. All right, so if you're the police chief and your brother owns a car repair service, or maybe your brother-in-law, that's not the one I thought it was. If you're the police chief and your brother-in-law or any relative of yours owns a car repair service, you as a police chief can't send cars to your relative's shop to be repaired. Violates ethics laws. Even if that brother-in-law does the best job in town, is it a brother-in-law? Son-in-law. Even if that son-in-law does the best job in town, offers the lowest prices, the law says it doesn't matter whether or not you get a good benefit. Okay? If you're the one, yes sir.
What if you violate and they get divorced? Then it's good?
Say that one more time.
What if your brother-in-law and then they get a divorce? Now you're okay?
Yes, you are. I don't like either one of my brother-in-laws. I have one on my wife's side, but we're being recorded. I love both of my brother-in-laws. One on my wife's side and one on my side. We had a case not too long ago involving a stepchild and involved a county. And the county was buying maybe asphalt or dirt. They were buying something from a supervisor's stepson. And we always took the position that a child included stepchild under the ethics law. And we took that case all the way to Supreme Court. Supreme Court said, no, it just includes your blood relatives. And so taking what the Supreme Court said, your blood children, your relatives who are your children, not your stepchildren. Taking that and applying it to ex-spouses, your ex is not your, or not ex-spouses, ex-brother-in-laws, your ex-brother-in-law is not your relative for purposes of the ethics law.
So that would go into the two brothers that work together at the fire department or the police department?
They'd have a hard time getting a divorce.
But they're stepbrothers?
Stepbrothers would mean that they're not relatives or under the ethics law.
They would have to quit.
No, stepbrother's different from stepbrother's the same as a stepchild, yeah. That would probably be okay. Half-brother would not.
Right.
Stepbrother would.
Well, you
Yes.
can't have your mom and daddy married.
Technically, that would be right. Now, you still got to deal with the nepotism law if you're talking about hiring, and I don't know what the outcome would be on that. We don't give out advice on that section.
Thank you.
So the Supreme Court's read those definitions pretty narrowly to mean what they say, and doesn't apply to exes and doesn't apply to your stepchildren.
What if they're divorced and they have children? If that's a year.
Talking about a parent, two parents. When you get divorced, you still got your children, so it wouldn't matter if it's your children by divorce.
So what I'm saying is the repair shop owner, he's the son-in-law, or
Mhm.
he's the brother-in-law, or somebody that works for the city. And if they get divorced and they have children, if he has to pay child support and the city does business with him, they're not the same thing.
Now, the question just got real complicated.
It did.
All right, so you have a police chief, and then you have a son-in-law who runs a repair shop, and the son-in-law has children with the daughter, and they get a divorce, and the son-in-law still has to pay child support to the daughter. We've got an opinion pending right now that's kind of close to that. And what the law says is you as a public servant, which is a police chief, can't use your official position to obtain a monetary benefit for your child in this scenario. And so the question is whether or not taking those cars to the repair shop is really going to result in a monetary benefit to your child who's now divorced from the owner of that shop. I don't know the answer to that. We've got an opinion that's pending. If you want to come to our commission meeting, it's 2 weeks from this Friday. 1 week from this Friday. We have an opinion dealing with that right now. Child support might not be enough because that's being paid to the grandchildren. Alimony, which gets paid to the spouse, the ex-spouse, might be enough. And so that might be that might raise an ethics issue that would at least need an opinion before you did it. Thanks for making it real complex. But we do have an opinion that's similar to that coming out here pretty soon, involving the school district. Okay, any other questions before we move on? All right, so we're moving on to a different section of the law. We're going to pick up things just a little bit here. This section of the law says if you're a public servant, so it applies to board members as well as anybody else, you cannot be a contractor, subcontractor, or vendor to the city for you guys. And you can't have this thing called a material financial interest in any business which is a contractor, subcontractor, or vendor to the city. The way that works for you employees, if you have a side job and that company serves as a contractor to the city, and you go work after hours for the contractor and they're doing a city project, if you earn, I'll just go ahead and tell you, if you earn more than $5,000 per year with that contractor, you may be in violation of this section. Okay? So this applies to having second jobs where you might work with a company that contracts, subcontracts, or as a vendor. So if you work at the hardware store after hours, after your day job, which is your public servant job, the hardware store may not be able to do business with the city. Okay? There are a couple of exceptions to this law. We're not going to get into those, but just know that there are some exceptions. But the general rule is if you're a public servant of the city, and that applies to commission members too, you may not be able to work somewhere that does business with the city.
What if you're a planning commissioner, can you work for the city as a contractor?
If you're a planning commissioner, can you work for the city as a contractor? The quick answer to your question is you have an issue under this section, but you may be able to under one of the exceptions. So the general rule is don't do it without getting an opinion. So if you're a planning commissioner and you want to contract with the city on a project, you need to contact the Ethics Commission. There's an exception that might apply depending on what you're going to do. That didn't answer your question. There are 4 or 5 exceptions to this general rule, and they get a little bit technical. It does depend on which department of the city you're working for, what kind of contract it is it bid out, how many bids were received, and what kind of services are you providing. All of those are factors to determine whether or not the exceptions are met.
And it also has to do, in our situation, an example might be Park Commission and Tourism Commission, for example, are separate. They are funded at the top level by the city, and they are affiliated with the city, but they are separate budgeted entities. So in some situations, it's possible for members of the Tourism Council or the Park Commission to have some contractor employment relationship with the city proper, as long as certain conditions are met.
Yeah, when I talk about a contractor, I'm talking about somebody who provides services. And when you start talking about separate authorities of city government, it's a lot easier. If you're talking about services and separate authorities of city government, it's fairly easy to fit within one of those exceptions. If you're talking about selling goods, which I know you said contractor, but I haven't told you all what contractor means to us. If you're selling goods, it gets a little bit more complicated than that. There's a couple of extra steps in the process. But the general rule is, you got a potential problem. If they're separate authorities and you're providing services, you might be able to do both. There are also things that people think are part of the city. Y'all have a municipal housing corporation. I think we've always treated those as separate governmental entities. They're so separate from the city. So you could probably do work with a separate governmental entity, even though it might have been originally set up by the city. So it gets pretty complex when you start talking about having multiple positions, but it's possible. Okay, any further questions? All right, the purchaser prohibition. You're a public servant of the city. You cannot be a purchaser, direct or indirect, at any sale that's conducted by the city. And that's going to include the property tax sale, any kind of surplus property sale. I can't think of any other kind of sale y'all have. Y'all sell anything else? Utilities? Y'all have a utility? Notice this section says you can purchase public utilities or things that are offered on a uniform price schedule. So you can buy electricity or water. Y'all do both, electricity and water? You can buy electricity and water even though you're city employees, don't fear. Okay?
And Sue.
And sewer, yeah. But surplus property sales, tax sales, and I'm told y'all do a really good job on policing yourselves on this. But if you're going to participate in any kind of sale that's conducted by or on behalf of the city, you could have a problem, okay? Law says you can't purchase them. We always see this at the community college, I told this earlier, we see this at the community college level all the time, where a guy who works in the maintenance barn at the community college comes and says, hey, this lawnmower is completely shot, y'all need to get rid of it, get me a new lawnmower. The community college sells it at an auction, surplus property auction. Some guy that nobody really knows shows up and buys it. And then 2 months later, the president's driving by and sees the lawnmower out on the community college employee's front lawn. All right, this law says you can't be a purchaser direct or indirect. So you can't send somebody else to purchase it for you and then have them sell it or give it to you. So you can't send a straw man in to do your purchasing either. We're going to skip the security section. Insider lobbying. Yes, ma'am. Oh, yes, sir. Oh, police gun. You want to buy a police gun? A gun?
I think it better not be a city employee as it is. I'm kind of pressed.
Police officers can buy their guns. I think when they retire, they got a special statute that says they can buy the service revolver. So you're okay. You can keep working for the city.
Being a small town, I like to go back to the other one. I feel kind of cloudy. Not on that. The whole cousins and nephews. You can hire your cousin and nephew. Here's the part I'm worried about. As a chief, I don't want to be paying nobody. I don't have to pay y'all no money back for making a mistake.
Yeah.
So-
You came in a little bit late, and I kind of breezed through it.
Yeah.
If,
I heard that, but
if-
it's direct brothers and sisters. It has nothing to do with first cousins and that, right?
You got 2 hoops you got to jump through. Okay. When you're talking about hiring, you got to call 2 different places.
I got that.
You got to call the Attorney General's office. They're going to get you on some of your cousins, I suspect, but you need to call them and ask them, can I hire my cousin? Because that law only applies to certain relatives, and Paul can probably tell you which relatives, and it only applies to certain positions.
Gotcha.
Okay? The ethics laws apply to the ones we showed. Your parent, your spouse, your children, your siblings, which that's your brothers and sisters if any of y'all are supervisors, and then the spouse of any of those folks. And so if you're not talking about those folks, under the ethics laws, you can hire them. Is it a good job to hire your first cousin? Even if you call the AG's office and they say, yeah, you can put them as a dispatcher because that's not a clerk. Is it a good job to hire your first cousin? I don't know. You're gonna have the whole department run by all your cousins and your third and fourth cousins. You can do a lot of hires that aren't illegal that could look really bad to the police
No, I'm
department
talking
too.
about that. I think you're misunderstanding.
Oh.
When you get into a position of a supervisor, or a
Mhm.
chief, or a manager, you have nothing to do with who was hired before you.
Yeah.
So that's the thing that I'm talking about. I want to make sure that something isn't violated. I'm not trying to.
Yeah. What the Ethics Commission has said is if you get put in the supervisory capacity over that person, eventually you're going to violate the ethics law. We can't sit on your shoulder and tell you when it's going to be, but if it's one of those relatives I talked about and you're supervising them, eventually you're going to do something that violates the ethics law. So somebody's going to have to make a decision. So if it's one of those relatives, it's not an automatic violation. Something's got to happen. You got to use your office before you violate it. We can't tell you when that will be, but it will happen. I promise you that. We got a lot of questions about that the first time. And that's a tough opinion. I told you it's a tough opinion, but the commission has been very consistent on that issue. And that's a tough area. Any other questions? All right, insider lobbying. You can't be paid by anybody to go lobby your own board. And the chief would call that bribery and put you in jail over it.
I got that.
I mean, you know what it means.
Post-government employment. While you're working with government, if you work on a specific case, decision, proceeding, or application, We call those matters in our office. So if you work on a specific matter, you can't leave public servants and go work on that same matter in the private sector and be paid to do so. Okay? So if you're in the process of negotiating a computer-aided dispatch contract with one of the companies that sells that product, and you're personally responsible for negotiating that contract, and it's a 3-year contract. If you retire as an employee of the city, you can't go work for that company and be the liaison on that particular contract. Now, you could go work for that company and call on other cities and work in relation to other cities, but you can't go work on the same contract that you were involved with for your city. That's the way that works. Insider information, this is one of the, we got several questions on this one in the early session. This section says, if you have information by reason of your position in government, and that information is not public information, or has not been communicated to the public, you violate the ethics laws if you disclose that non-public information to anybody who could benefit from it. So the disclosure itself is a violation, regardless of whether or not the person you disclosed it to goes and does anything with it. So if you get information through your government service that's not public information or is not being communicated to the public, make sure you're not the one out leaking that non-public information. Okay? We had several questions about that in the early session. But this was one of the ones where disclosing it alone violates the law, even if they don't even take it and use it. Disclosing it to somebody that could result in a pecuniary benefit in any way to anybody is a violation of the law. Okay?
Andre, folks from your office had some questions about this morning, because planning and economic development type stuff is where this can come up. If y'all have somebody who's come to you with a project plans or, a proposal or something like that, it is possible that they have presented you information which may technically be a public record because they filed an application, but it's still not communication that's been communicated out to the public. And a disclosure of that information could potentially be used by a competing developer or, a competing bidder for the same site or something like that, in a way that could trigger this section.
No, I think to me, that's a hard problem because people are so loosey-goosey with emails, and emails feel like they're public information on a government.
We'll get to that.
So that's the part I have trouble with, is certain people using emails too much. Not our offices, but people that perceive their citing as a confidentiality or something.
And where we are starting to get a couple of cases on this section, this has been an area where we historically have not received a lot of cases because everybody used to use the phone, so there's not a good paper trail, and it's kind of hard to figure out who told who what. Now with text messaging and of course, like you said, email, we're starting to see a little bit of a paper trail where we're able to prove a case. When we bring a case, we have to prove it with clear and convincing evidence. And so sometimes it's hard to make a case without some type of paper trail. But we're starting to see some of these cases where somebody finds out somebody's coming in on the bypass, and so they text a friend, "Oh man, this is cool." Well, if that could result in a pecuniary benefit to whoever you disclosed it to, you violated the law. So eventually we'll have a pretty big case, I would imagine, on this section. So your folks need to know, and I tried to say this, and I said it very inartfully earlier this morning, when that information is no longer secret is really a matter of fact that has to be determined on a case-by-case basis. So, when is information public? It's kind of hard to decide sometimes. There's no bright line test on when is information public. So if your folks are learning things because of their position and the general public doesn't know it, that seems pretty clear that might be too soon to be disclosing it to folks. So what we talked about is you need to be real careful that any announcements come through either the developers or through some joint effort of the mayor's office or where there's an official announcement. But we're starting to see some cases on this type of stuff.
So, it's economic development when they're looking at sites, but when it goes to site plan review and the planning commission hears it, it feels kind of out of the bag.
Yeah, and I think you could have a difference of opinion, and I think your lawyers would tell you to err on the side of caution. And once you start talking about things in public meetings, you get questions like, well, did anybody show up to the public meeting? And if you had a public meeting, is it really, is at that point, is the cat out of the bag, or do you have to wait until some other point? There's not a lot of guidance on that.
Chief
So I
Puzzle
would-
Meeting fell in the woods.
That's right.
But I mean, a lot of our public meetings are broadcast
Yeah.
on local access. I mean, I think by the time we get something that actually goes in front of the planning, we never have a meeting of the aldermen of the planning commission where nobody's there.
Right.
You know,
It's-
some of our other.
At
boards-
some point, it becomes public. There's not a whole lot of guidance in the law about when that is. But I would tend to think if you've had a public meeting, you're getting real close to it being public information. It's at least available for the public at that point. So,
But the takeaway is, I mean, that if you receive knowledge, if you receive information as a result of your public service, I mean, the default ought to be, keep it under your hat.
Yeah.
I mean, the fact that it's not always a black and white issue, and that it's a factual determination, and that these guys may at the end of the day disagree with you, if somebody gets upset with you, means that, you know, the information that you get in, shouldn't be stuff that you go out and talk to your friends about, over dinner, if you hadn't aired it out in a public meeting or something.
yeah. And this statute's really rough because it says in any way that could result. So the person you disclose it to doesn't even have to run with it and use it. It's just if they're in that position where they could use it for their benefit. So it's one to be real careful with. And there's just not a whole lot of guidance. So I think your attorney's giving you good advice, but I think you be careful. They say loose lips sink ships. So be real careful with the information you get through your government position.
And that's not the only, jumping ahead or behind, and look at it, and that's not the only reason that you could learn things as a result of public service that you need to keep under your hat. If you are either a board member or you work for a board and you go into executive session matters could fall into this, because you could be talking about property development, economic development type projects. You could have a personnel matter come up in executive session that you really don't need to be talking to anybody about, because those you are precluded from releasing personnel records and stuff like that. So it's, especially if it's anything that's discussed in an executive session, you need to be careful about saying it to anybody else.
All right, we took about a 5-minute break this morning. Do y'all want to take a quick break, or do y'all want to keep going? Preference? I know I'm really excited. All right. I think I can finish up in about 3 more hours if y'all just skip the break. Public Records Act, we're going to kind of run through this. I'm going to skip some things. You guys, the city clerk was here this morning. I know she handles most of your public records requests. A couple things I'll say to you all you employees. If somebody thinks that you violated the Public Records Act, or we jumped out of ethics, okay, and we're talking about a different topic, we're talking about the Public Records Act. If somebody thinks you violated the Public Records Act, they can file a complaint against you, and that complaint goes to the Ethics Commission, and the Ethics Commission can hold a hearing and figure out what happened, and if the Ethics Commission decides that you violated the Public Records Act, you can be fined personally, okay? You can also have to pay the costs of the person the cost that the person incurred in having to bring the public records complaint, which in the right kind of case can also include attorney's fees. All right, so if you want to get into really hot water, you'll mess around with somebody's public records and get a complaint filed against you, it can really turn bad real quick for you. So this stuff's real important because it can have, and all this stuff is personal. You could be fined personally. You could be required to pay their fees back personally. And this applies to all of you. I know the city clerk handles public records requests. What we see sometimes is that somebody will send a public records request to somebody who's not the city clerk, and the person who gets it won't send it to the city clerk, and you get a complaint filed against you. So I would encourage you, if you get something that looks like a public records request, get it to your lawyers, get it to your city clerk. They have developed forms to fill out to request public records. They've got the right office handling those public records requests, but the thing you can't do as a city official is ignore something from the public and expect it to be a good outcome. I'm not saying you automatically violate the Public Records Act if you don't forward that to the city clerk, but we've had cases where something sits for a couple of days on somebody's fax machine and doesn't get sent over to the city clerk's office in time, and the city clerk ends up not responding to the public records request on time. And so you can really cause some problems for your city by not paying attention to requests for records. So that's what I would encourage you all to make sure. If you get something that looks like a public records request, get it to your lawyers, get it to your city clerk. And to kind of segue into the Public Records Act, the legislature has told us that any document or other record related to your government business, it's a public record, okay? So if it's a document related to your government business, it's going to be a public record. That's real broad definition. The other thing the legislature has told us is that the public, whether you're from Oregon or Batesville, has a right to inspect or copy those records, okay? So it doesn't matter that you live out of state, it doesn't matter you live down the road, the public has the right to inspect or copy those records. If you start out any of your public records issues with that mindset, that would cut down on a lot of our violations we see under the Public Records Act. Okay, legitimately, there are a lot of records that are exempt from production under the Act. Okay, and we'll talk about a couple of those. I know y'all don't handle these on a daily basis, but investigative reports would be a good example. We'll talk a little bit about incident reports and investigative reports since we have a member of the police department here. But you guys should know, if you ever have to deal with a public records issue, you need to start out with the mindset that if it's about government business, it's going to be a public record. Okay? The question we always give, well, what about electronic records? All right? If you send an email and it's about government business, it's probably going to be a public record. Okay? Go ahead and assume it is. If you send a text message and it's absolutely about government business, you've probably just created a public record. Okay?
Even on your personal cell.
The question is even on your personal cell phone. All right? If you go look at the definition of public record in the Public Records Act, it says any document that is prepared in furtherance of the government's business. Okay? If you're a government official or you're an employee, right? If you're a commission member and you've prepared a text message on your personal device, if you're an employee and you've prepared a text message on your personal device, and that text message is about government business, absolutely that's going to be a public record. The Act makes no distinction about where the document actually resides whenever you make it. Okay? You can use your personal pencil and write a note on your personal, a memo on your personal three-ring binder notepad. And if it's about your government business, it's in furtherance of doing your job, even though you used a personal pencil, even though you used a piece of paper that you brought from home, you've created a public record. Okay? So it does not matter. You can't go home and work from home one day, which we all know y'all, when y'all say you're working from home, y'all taking the day off, right? You aren't really working. When you work from home and you log on to your personal email and you start sending things to yourself or your bosses or your coworkers, it doesn't matter that you're sending that from a personal device. If it's about your government business, you can almost be guaranteed that that's going to be a public record. Okay? Now, do people put things in text messages that they would never dream of putting in a memo on an official city letterhead? I do sometimes. I'm telling you guys, you need to be careful what you put in text messages. This is kind of outside the Public Records Act. This is a little soapbox. But you guys need to be very careful what you put in text messages, what you put in emails, because what you're doing is you're creating a record that the city might have to go get from you. And if it has stuff that's inappropriate, you can just go ahead and rest assured somebody's going to get a hold of it. Okay? So you need to treat text messaging just like you would a letter written on city letterhead. And the casualness of text messaging is so efficient. You get a lot done with text messaging, but the casualness of text messaging is what gets folks in trouble. And that's a little bit outside the Public Records Act. I'm kind of preaching at you guys. But if I were y'all, I wouldn't send anything via text message unless I would put it in a letter to somebody. Okay? I'm going to be professional in my text message. I'm not always, but I'm going to be professional in my text messages. I'm going to be careful about the words I choose. And I'm just going to go ahead and anticipate that somebody's going to get a copy of it. Okay? And you know what happens when you hit the delete key of that text message, the delete button on that text message? It's not gone. It's somewhere. I can promise you that somebody got it on the other end. There's probably a copy of it on somebody's server. Who knows whose server it's on? And so, I mean, you can rest assured that it's out there somewhere. So you guys have got to be really careful communicating via text message, whether it's a city phone or whether it's a personal phone. Okay? I'm preaching at y'all a little. I'm sorry about that. This is a case that we decided. It was filed against the Rankin County School District. The people, it's been in the papers a little bit down in the Jackson area. The people have filed some suits against the Rankin County School District for bringing prayer and Bibles into the school, and the school's been fined a couple of times. And essentially what the people wanted in this case were any emails that mentioned the word Bible and some other topics. And the school district took the position that the emails weren't public records, and what the commission said is if it's an email about school business, which we tried to define what that was, it's going to be a public record. Okay? The flip side of that is if you email somebody and say, hey, would you like to go to lunch on the square, that might not be a public record. It's not a working lunch. It's a purely personal note. My encouragement to you is not use your business email for anything that's personal, okay? Because what the Supreme Court has said is that we're going to err on the side of openness. So if you got an email that's not real clear, whether it's about your official work or not, the commission is going to tell you to err on the side of producing it. So if you got one that's kind of embarrassing and it's not clear that it's about work, the commission's probably going to tell you to produce it. So you got to be real careful what you put in your emails and your text messages. But emails are public records. Text messages, I just covered that. And this is kind of the test here. Any text message used by a government official in the conduct, transaction, or performance of any business, transaction, work, duty, or function of the government is a public record. You know what that means? If you send it and it's about your work, it's going to be a public record. Okay? Even if you put inappropriate comments. All right. Any questions about that? All right. You have to turn your cell phones in at the door. We're going to scan them all before you leave today. Usually we get some pretty bad size with this stuff. Y'all use text messages? Anybody use text messages? Okay, costs for responding to public records requests. I'm going to cover this with you guys. I meant to cover it this morning, but I ran out of time. When the city has to respond to a public records request, they may be able to recover the costs for responding to that request. So if a public records request comes in to the city clerk and you get contacted about the public records request and pulling records related to public records request, the city may be able to recoup whatever time your department employees have to spend pulling records. And what the legislature has told us is that it's acceptable to charge the labor charge for the person who is the lowest paid yet still competent to respond to the request. So if you all get a request and you have to go do some research and pull records, it's really important that you keep up with what amount of time it took you to go pull those records, and then make sure that if you get asked to compute what your labor charge was, that your labor charge is not necessarily the director of the department. Sometimes somebody a little lower than the director can respond. And then, of course, the attorneys know that in the right kind of circumstance, they can even charge a little bit for their review. But make sure that if you're involved in pulling records for a records request, that you keep that in mind. And I would recommend that you log your time, whatever time you spend actually working on the request, and actually keep up with the amount of time that it takes you to respond to the request. Because the public body, the legislature has said, the public body is entitled to recoup the cost for responding to the request. Now, if you work in a department, I don't know if I should say this or not, if you work in a department that charges a flat fee for records, do all your public records requests go through the city clerk?
They should.
Okay. If you work in a department and you're charging a flat fee for getting records, you're probably violating the Public Records Act. Okay? Flat fees, you have to jump through some hoops in order to really justify those. Okay? I've seen it with police departments who charge $25 for a copy of an accident report. You got to make sure you jump through the right hoops in order to charge those amounts. We haven't had any cases involving those. I'm kind of surprised we haven't. But you need to make sure, if you're doing that, you probably ought to get with us or get with your city attorney and make sure that you jump through the right hoops in order to charge for those records.
And just, Chris mentioned this a minute ago, because he and Lisa were talking about it. Lisa and Ashley have a form. So anybody who,
It's on the website.
yeah, anybody who's not aware, y'all get a, for all I know, y'all have something, different over at tourism, but if y'all get somebody asking for documents, you need to go to their office and, or just tell the folks, listen, there's a form on the website, fill it out and send it in to the city clerk. Mark, I think you called me about that before, about somebody asking you for a bunch of documents. You don't need to take it on yourself to answer or just say, I forget that, I'm not going to give you anything. If somebody's asking for documents, make sure you go straight down.
Yeah, first thing is communication. At a minimum, you need to contact the clerk and say, hey, what do I do with this? Contact your lawyer and say, what do I do with this? And the thing you don't need to do is ignore it and then not even communicate to the person asking for the records. That's like the worst. Somebody gives you a public records request, you say, oh, they didn't send it to the right person, and you never tell them that. Then you put yourself in a position where you might actually be violating the Public Records Act, even though they didn't follow your policy.
Touch on the time frames.
Time frames. When you get a public records request in, you have 7 working days to respond. And I didn't talk about the response because y'all probably won't be involved in writing a response. The response either has to give them records or deny the records and tell them why, with a real pretty specific reason why you're not giving them records. It has to be done within 7 working days. You get a big request, you can extend it a little bit. And what the commission has said is you don't have to shut down the agency. If you get one that's going to take 6 weeks, you should probably, number one, get in touch with your lawyers and figure out how we're going to do this. But under the act itself, under the words in the act, you can have up to 14 days. But a regular request at 7 days, you can ask for some more time, but you need to have a good reason to ask for more time.
So
It
what
doesn't-
happens,
I'm sorry.
I'm sorry, what happens if they never come back? I mean,
They never come
people,
back.
you know, that you say, thank you for your request, can you be more specific? Attached is a public records request form, and then they never come back. I mean, I feel like I didn't do anything wrong.
Pick up the phone and call the Ethics Commission, and we'll be happy to talk with you informally about what you've done, and we'll give you our impression, whether or not you've complied with at least a good. What we look for in these cases is when we get these cases in, you usually fit them in one of about 5 different types of boxes. When we get these cases, we're looking to see what was requested, and I skipped some of that. What was requested, what was the response, and then what happened after that. And so if you got a request where somebody said, give me every record in the entire city that ever mentioned Bible, which might include all your tax records, it might include everything, we're going to look to see whether or not the committee, the city, responded to that request. Hopefully you would respond and say, that we can't identify all those documents, much less respond to your request. And in that scenario, I think you would be okay. Your scenario, you'd probably be okay if you communicated to them timely that they've got to fill out a form and that they need to go through the city clerk's office is what it sounds like to me. Y'all would even handle those record requests too. If you communicated those 2 things, I think you would be okay. Communication is key. What we usually see is it sat on somebody's desk for 6, 7, 8, 9 days. The person had to call you back a couple of times and then you told them.
I responded immediately, but I never heard from them again.
You can't make them request the records. But I would, if I were you and I was trying to cover myself, I would get that information communicated to my city clerk.
Right.
And then I would so you're taking that off of your back and you're putting it on the person who the city has decided ought to handle.
That was a strange request. It came on a fax or something. Of course, God bless America, we have the right to all public information. And then, it's like, well, what do you want? And if you have a public information request,
Public information.
then, can you be more specific and send?
Was the address Leaksville? We get a lot of those from Leaksville, the prison over there. The prisoners have a lot of time to write and ask for records. But I mean, communication is what we look for usually. You don't have to guess what they want. I mean, there's no. Good question. All right. The reason I tell you to keep up with your time, if you go pull records, the Supreme Court has said any attempt by a public body to impose fees exceeding actual costs is a willful and knowing denial, and you could have to pay attorney's fees. So if your department is involved in pulling records and you don't keep up with the number of hours it took you, and you can't prove it when it goes to trial, it creates a proof problem for your lawyers. So make sure that if you're helping respond to public records requests, that you kind of keep up with what amount of time you had to spend doing it. Okay? I'm gonna jump through this so we can try to get finished. I wanted to touch on this, personnel files. There's a case out of the Southern District Court of Mississippi, United States District Court, Southern District of Mississippi, where a federal judge imposed a $180,000 judgment against Jackson State University for releasing some personnel records to the Clarion Ledger. And when you guys get these public records requests, you need to really go through the folks who've been designated by the city to handle those things. This was a case where the department director for Jackson State released some records to the Clarion Ledger. Clarion Ledger wrote a story about it, and the judge said you invaded the person's privacy by releasing a personnel file. If you go look at that exemption says that stuff is protected. You can't release it, okay, unless the person consents to it. So that's one of those exemptions that you can get in trouble if you actually release the records. With investigative reports, the department usually has discretion on whether or not they want to release that stuff and what they want to release. But things like personnel records, you got to be real careful. And that case is a good example of why Judge Reeves found that Jackson State invaded this person's privacy by disclosing some private facts about the person's life that you would expect to remain private. So
I remember this.
$180,000, ma'am.
The person sent in a request for a zoning verification letter, and at the top, it said, "God bless America, and we have rights to all public records." I answered the zoning verification letter, and I said, if you have a request for another a city record, here's the form, and here's the clerk, so I don't think there's anything wrong.
Yeah. She said that she remembered the request, and it was there was one little piece of it that was specific that she responded to, and then said, if you have a request for a specific record, let us know. And that's probably a legitimate response. I would still encourage you to get with the department at your city, get that off your back and get it to the right department too. I would do both.
I copied it.
Okay, if you all have public records that have been furnished by third parties that contain proprietary information, you got to be careful not to disclose that. You might have to give them notice before you disclose it. That's another reason to work through your attorney. So if you have information that from a third party they're required to submit to you, and it's confidential or proprietary commercial type information, you might have to get their permit. You might have to let them know before you produce those records. Make sure you work through your attorneys if you've got other people's stuff before you start sending it. Personnel files, confidential business information. Make sure you're working through your attorneys before you produce all this stuff.
What about cases like, Loretta and I work in the court department, so what about cases where we have, like, people are going through a divorce, and whichever one may come in and say, well, I know my husband got arrested for a DUI, and I wanna know, I want a copy of the police report, I want a copy of the file, but let's just say the case is still pending, are we at liberty to give that to that individual?
Court files are generally open to the public. You may want Paul to tell you whether or not you need to work through them before you produce a court file. If it's in a court file and that court file is public and has public access, do y'all use the electronic files, the electronic court system?
Not in city court.
Not in city court, you don't?
They have a system, but it's not one that's.
This is electronic. At Gulfport, I was talking with them not too long ago. They've got an electronic file where everything gets dumped electronically and everybody can access it. It's imaged. It's not really, everything's imaged. They don't have paper files of everything. If it's in a paper file and that file is not sealed, most likely you've got to give that stuff up. Now, I know that you need to be real careful, about things with social security numbers and other identifying, identity theft is a huge problem. And I think you've got to, if your court doesn't already do so, you need to take some precautions not to be releasing people's social security numbers and other personal identifying information. If it's in a court file and that court file is not sealed, then most likely you're going to have to give that stuff up.
That's like, Beretta's office, they have all everything's just online. Documents and stuff come down, it's over on the Delta system, pull it up immediately. You don't require to do that, but, folks have the same right to access once it's undergoes, things as an investigative file.
And when they come in, even though they're, if this is like, we have a lot of people say, we're going through divorce, and I wanna know what all these,
That's personally identifiable information, I think definitely needs to be redacted. And frankly, you know, I know folks come into y'all because y'all court, they're looking for stuff off of your system, but it wouldn't hurt at all for y'all to say, you know, our court records are just city public records, and there's a form for that.
Yep.
You wanna go say, you know, here's my sorry ex-husband's name, and I want whatever you have on his DUI, and fill that out with public records form, and, you know, Ashley then can come and give y'all that. I mean, that would probably make it easier for y'all to gather, because you'd be working with, be working with them.
That's the policy that we follow. It's just that every once in a while, we get somebody that bypass Ashley, they come up to us and they want to know what Jay Doe, John Doe,
Yeah, and one thing I did skip out, you know, it's called the Public Records Act, not the Freedom of Information Act. So they're required to ask for a record, and then you're required to either give it to them or deny it and have a really good reason. Okay? They're not entitled to just come up and ask questions, right?
Or tell them it
Open-ended
doesn't
questions.
exist. I mean,
Yeah.
that's, if there's not a record, if it doesn't exist, that's the right answer.
Yeah.
And there is that thing there where you don't have to create something that your system does not automatically generate.
Yeah, the Public Records Act doesn't require you to create records. It gets a little more complicated with electronic records where your programs have recording features. It's spinning the information out of a database is not always creating a record if you've got a print function. But yeah, you don't have to create, give me a list of all cases that Johnny has been, charges have been brought up on Johnny. If you don't have a list of those cases and don't have a print function that would create a list of those cases, you don't have to do that. You know, my guess is y'all probably can query your database by name and print off a list. So you might, you know, that it would be very reasonable for you to do it, and you might have to do it if you've got a query that's built in. But yes, you don't have to create a separate document. Like if they ask, you know, give me the list of all cases, who the investigating officer was, when it went to trial, how long the trial lasted, you don't have all that stuff in one place, you don't have to go create a list for them. So yeah, there's no reason you have to create a document. Okay? I did want to mention investigative reports very quickly. Do y'all use an incident report? Do y'all have an incident report?
We do an incident report on every, especially if it's a arrest or anything like that, we do an incident report on it, and, an arrest report.
The Public Records Act has a definition of incident report in the Act, and what I find most of the time is the definition in the Public Records Act is a little bit more narrow than what your incident report will have. In my experience, the police incident reports have more information than you're required to produce. The incident reports are public records, and people are entitled to them. But and I say incident reports the way it's defined under the Public Records Act. We find some municipalities that say, hey, there's just too much stuff in our incident report, you can't have it. And what the commission has said, if you have an incident report, or if you have a document that has the basic narrow incident report information in it, but it also contains some other things like victim information, the victim's address, witnesses that you might utilize, anything that might disclose your investigative techniques, anything outside of there's just a real basic definition of incident report. Anything outside of that would need to be redacted, and you would still need to produce the incident report.
We followed the opinion that came out, and our incident report pretty much
Good.
followed what y'all said, and then we have the investigative report.
That's perfect. A lot of places.
We haven't had any problem yet, we give them that incident report immediately, and that's pretty much, they call in on one question, we just tell them we can't answer.
Yeah, that's perfect. We still have multiple agencies who are just not, they don't know about the Public Records Act, they've never had to really deal with it, or they don't care, I'm not sure which one. And we had a case last month where the police chief just wouldn't give out anything. You know, he violated the Public Records Act. And the Greenwood paper was all over it because they were the ones asking for the records, and I'm sure they wrote ugly articles about him. But if y'all are doing that, that's perfect. And that's the way to do it.
We've
So.
done it both ways, and we kind of learned our mistakes.
That happens sometimes too. Okay. You guys may not care about this, but we do have model public records rules. We've gone through and developed some model rules that the city would be more than able to take and adopt them, change them, do whatever they want to do. They're not binding on the city. They address a bunch of topics. If y'all have questions about stuff, there's a chance that we've addressed your topic in our model public records rules. Now, they're not binding on you, but they do, generally, they represent good practices whenever you're dealing with public records requests. You guys have a centralized process. Y'all don't need to go read them. Y'all need to make sure you get your records requests to your city clerk and let her deal with figuring out what the answer is. So just make sure y'all are communicating with your city clerk on public records issues. Open Meetings Act, yes, ma'am.
Whenever, is a background, we get a lot of background checks, and they don't always come from other police departments. You know, whenever they come from another, law enforcement agency, we go ahead and answer those bids. But sometimes they come from different companies that have been hired to do a background check on an applicant. So with those, basically, we need to let them go through and file the public records request, or can they just send those to us directly?
I would suggest any records request that you receive, if your city has a centralized process for doing it, you need to talk with your attorney and figure out whether y'all are gonna handle those. And may need to talk with your mayor and figure out whether y'all are gonna handle those or whether or not those need to flow through your city clerk. You're talking about like background check where they send off somebody who's consented to having their NCIC record searched or something like that
Or either they've applied for a job.
somewhere?
Yeah, somewhere, and the agency is just sending us something to see if they have a record because, quote unquote, they were a student that lived in Oxford. So we just want to see, you know, what kind of record they had while they were there. And then they'll send like a copy of the release form, showing what they signed something saying, but it's okay to give this information to Edward Myers, whoever. So I'm just kind of, and of course, you know, bill from other law enforcement agencies, which is fine, and we honor those. But sometimes they just come from companies that have been hired by another company to do background checks on applicants.
Yeah, that's a process issue that y'all just have to figure out how you wanna deal with that.
Yeah, the big picture issue is that if you're talking about dog records and then district court records, like we talked about a minute ago, that there's no difference between law enforcement agencies asking for it and a private company asking for it. I mean, it's there, and especially if it's been consented to. I don't think that's necessary, but if you know the person's not gonna object to it, that's always, what thumbs up.
How many commission members do we have in here? 3, 4, 5, 6. Okay, I'm gonna jump over this real quick and then we're gonna quit early, we're gonna quit on time, hopefully. Open Meetings Act, your meetings have to be open to the public. Do y'all ever have to go in executive session at all? Have y'all ever had to go in executive session? Okay, if you do, there's a couple of steps you gotta jump through, and if you don't jump through them, you violate the Open Meetings Act. And I'm not gonna go through each one of those steps. I've got a short checklist that I can get to Paul, and he can get it to you all. And it comes directly out of the Supreme Court case that tells you how to get into executive session. And the bottom line is, if you don't jump through all the silly hoops, and somebody files a complaint against you, then the commission's gonna say you violated the Open Meetings Act. And they may not fine you if it's a little technical violation, but you know, whoever filed the complaint against you is gonna be able to say, yeah, they violated the Open Meetings Act.
If you only vote once to go into executive session, you did it wrong.
That's a very good, that's a very good statement. If you're only voting once to go into executive session, or if you're just kind of going into executive session with no vote, you're not doing it right. If you're not telling the public a pretty specific reason why you're going to executive session, then you're probably violating the Open Meetings Act. And I didn't say kinda, I said pretty specific. You gotta give as much detail as you can under the circumstances. The law says you have to, the Supreme Court has said you have to. We still get cases all the time. Board of Alderman meeting, we're going into executive session to discuss a personnel issue. You really can't tell much by that description. The Supreme Court has said that a lot of times that's not gonna be enough. And so it's one of those, lawyers hate this, it's kind of a floating target. The Supreme Court has said, and the Ethics Commission has said, you gotta be as specific as you can under the circumstances. So if you're going to executive session one vote and you're not providing a pretty specific reason, then you're probably violating the Open Meetings Act. And you can be fined up to $500 per violation for a first offense and $1,000 after that, and it comes out of the commission member's pocket, which takes your commission pay down to negative, right? So, be real careful when you're going into executive session. Make sure, I would encourage you to get this checklist. I've got it, it's later on in here. We're not gonna go over it today. It'll take me 20 minutes just to go over it. But there is a process, and the Supreme Court has said it, each step matters. No matter how ridiculous it is, basically what they said, the process matters. How you get there really matters. Okay? A couple of things I did want to preach to y'all about, and I don't know exactly what is a meeting. Okay? The statute defines a meeting, I paraphrase here, any gathering of a quorum of the public body, which is going to include your commissions. If your board of aldermen has committees, their committees, if they have a quorum of their committee gets together, they have a meeting. So your commission is going to be, it's a public body because it's a board commission. If a quorum of y'all get together, I'm going to use quotes there, then you've had a meeting. Okay? And what we found is that there's a lot of different ways for folks to get together. And one of the ways that the commission has said you can get together, this involved a case against the city of Columbus. It's on appeal right now, so who knows how it might turn out one day. But in this case, the city council for Columbus had 6 members, and 4 of which would constitute a quorum. I believe that's right. 4 of them would constitute a quorum. I think it's in their charter. They decided that they would have a meeting. They decided they'd have a gathering where half of them got together in the morning, 3 of them, right, less than a quorum, and the other half of them would get together in the afternoon. And in that meeting, the mayor came to both meetings and kind of presided and gave information out over both meetings. And the Ethics Commission said, even though y'all weren't gathered in one place physically present, a quorum of you guys got together and deliberated a topic under your jurisdiction, which a meeting is any gathering, whether in person or by phone, to discuss a matter under the authority of the public body. So the commission said that even though those meetings didn't occur at the exact same time, they were pre-planned, they divided up, met on the same topic same day, the commission determined that that was a meeting for purposes of the Open Meetings Act. They violated the Open Meetings Act by doing so. Here's a case we had involving the Yazoo City Board. In this case, the mayor, it doesn't have to be a mayor, right? It can be anybody on your commission. It can be the employee that's assigned to your department. But in this case, it was the mayor. The mayor telephoned a quorum of the board to talk to them about a topic that they were dealing with. And when the mayor got a consensus, the mayor stopped making phone calls. They were never in the same place. They weren't on the same telephone line. The calls took place at a different time. It wasn't like they had 3 phones that they were working at one time. And the commission said the phone conversations constituted an illegal meeting. Okay? So you have people who are not even gathering in the same place now where you can have a meeting. And so the case we haven't gotten yet is what happens when your board emails around a topic and discusses a topic via email. You know, how is email any different than a telephone? Email may be worse than a telephone because everybody might be on the same conversation. Okay, so what happens when we can go, because y'all are keeping your public records, right? Y'all are keeping your records because you're not going to destroy public records. You're keeping your public records even though it's on your personal email account. But y'all are debating a topic that's under your jurisdiction. Guess who's not getting to see that debate? The public, the applicant, the person who has skin in the game. The public's not getting to see it. The newspaper or the blogger who likes to write bad about you. Y'all have bloggers up here? Okay. The people who like to watch your meetings and disclose to the rest of the public in town what's going on. They're not getting to see your debate. Okay, and you're debating a matter that's under your control. Have you violated the Open Meetings Act? It seems more blatant than a telephone poll to me, which was the Yazoo County case. You're not all meeting in person, but I can tell you a deliberation that occurs between a quorum of your board is probably going to be a meeting of that board. And if you violate the Open Meetings Act by sending around emails, then you probably, there's going to be a trail of it, and you very well could be found in violation of the Open Meetings Act.
I have a question.
Okay?
Recently the newspaper messed up on a legal ad, and when you email the board and say, I'm sorry, we're going to have a special meeting, the paper messed up, and everybody talks and responds, does that follow your line?
The question is, the paper messed up, because we know they always mess up everything, right? Especially when they're writing articles.
This is a legal ad.
Yeah, they even mess up legal ads. The paper's supposed to publish a legal ad. They somehow have messed it up, so it messes up your requirements under the statute that you publish a change of some sort that's coming along. And the city employee, being very prudent, emails the board, the commission, and says, hey, this is messed up, we've got to have a special meeting to do something, I'm not sure what y'all have to do.
Make up for what we didn't have.
And then the board engages in some kind of discussion about what happened,
No,
right?
they just said we could meet next Thursday.
Okay, so you're literally scheduling a meeting, you know. I have a personal, are we being recorded still? I have a personal opinion on that.
Talk on, Chris.
I have a personal
Into
opinion
the
on,
camera.
for all of you that aren't here. My personal opinion on that is if you're literally trying to figure out a time to meet,
Mhm.
and that's all you're discussing,
Yes, sir.
then that would probably be okay. I don't think that's a best practice, though. What I would suggest is having that email be blind copied to everyone. Because we know what ends up happening is somebody makes I'm available next Thursday. What can we do to the paper for messing this up? And then somebody else responds, says, I'm available next Friday. I say we take legal action against the paper or we go forward. And so now you go from just scheduling a time to now you're discussing what to do about it. And you can just very quickly, it turns into a deliberation by your board. And everybody's seeing it. So my suggestion is that on your scheduling, we've done it before where we send out an email that says, is everybody available for a telephone call next Friday? And we've done that where we send it to everybody, and we've gotten an appropriate response back, and we've done it where we send it to everybody via blind copy, so that when they respond, they only respond back to the administrative staff, which is us. I would suggest the best practice would be to send that type of email out. The bottom line is the staff has got to communicate with you at some level. And what doesn't need to happen, though, and what's so easy to happen with email is that y'all deliberate whatever issue it is that they're trying to schedule. So I suggest either calling and seeing if you're available and not discussing the issue, of course, or emailing you and asking you blindly to each one of you, asking you if you're available on a couple of different days.
This is what we've called in our office. I know some of y'all have heard me say this, is the don't hit reply all.
Yeah.
Some of y'all gotten emails from me that say XYZ, don't hit reply all. Because it is very important for the mayor or your executive director or your planning department director or whoever to be, or your attorney to be able to provide you as a group, as a commission, as a board with information. And it's also important for you as an individual board or commission member to be able to ask your attorney or your mayor or your DD or whoever, what do you mean by that? Can you give me some more information? So it's appropriate for the first email to go out to everybody. It's appropriate for you to respond back individually and say, I need some more information. What you shouldn't do is hit reply all so that everybody's getting it, because as soon as you do that, there are 20 more emails that are going to follow, and everybody is discussing a substantive issue. You always, if I can tell you the number of emails I get that have been bouncing around between board and commission members for the last week, and I'm reading down thinking, no, what's the point of having a board meeting at this point? Because everybody's already been deliberating the issues. So when you get those emails, and the administrators, when we send them around, we should be thinking about putting everybody in the BCC column so they can't reply all. Those kind of deliberations, those kind of talks are supposed to happen in the public eye, in notice meetings. Sorry.
Do you have a question?
Yes, sir. I think I know the answer. I won't ask it again. Not always, so a lot of this stuff between the mayor and alderman, and even department heads, I'm assuming that ignorance is no excuse for breaking the law, so at some point in time, I'm looking at that alderman, it's on them or us to learn the law. It is someone teaching them the law. A lot of this stuff that is saying, I don't think that they're learning, we are learning here today, hasn't really been
Yeah.
Lord, not right. I've been in some of those meetings with you, Paul, but.
Welcome to this room, Joey.
I think Chief is saying that the,
We've been pretty practical. We recognize that y'all are not experts in all this stuff, although your board members probably, if you're going to run for office and be on the board, you probably ought to go ahead and take the time to be responsible enough to understand the basics of the law. And, you know, what I can tell you is we've tried to be very educational in most of our opinions. The commission is not out to get anybody. You know, the reason I'm here today is to kind of give y'all a little bit of information, and I mean, we could talk for, I do a 4-hour class on this stuff and still don't get to everything. But, I mean, the bottom line is, some of these issues are kind of tough, like the email issue and the text message issue. If y'all all get on Facebook and comment on the same closed group, you know, could that be a problem? There's not a lot of guidance on that type thing. But we're starting to see some of that. But we're not out to get anybody. And, you know, we've got some repeat offenders who are problematic that we've dealt with. And we're trying to educate you guys. And we do treat I just work at the Ethics Commission. I don't get to make the decisions. I make recommendations. But we have really taken an educational approach in most of our cases and have tried not to penalize folks who are good, hard-working folks who work hard for their paychecks. And yeah, it's on your board members, because the Open Meetings Act is against you guys, and it's out of your own pockets. It's not, you know, it's not coming out of the police chief's pocket. It's not coming out of the taxpayer's pocket anymore. Used to, the public body could pay for the fines, but that's no longer. It's the individual who can be fined. So yeah, there's some incentive to learn how to deal with these things. But then, you know, some of these other issues are tough. The email issues, and if you send a text message to your entire board, are you going to be meeting? I would say, yeah, if you're texting your entire board in a thread, you're probably engaging in a violation of the Open Meetings Act.
Could you do, before everybody has to get up and leave, 2 minutes on telephone meetings?
Yeah, I don't know if I could talk that long on telephone meetings.
Just briefly touch on it.
Have y'all, does your board do telephonic meetings? What board are you on? Tourism Council. Telephonic meetings, ma'am?
Is there something about notice if you do it?
There's a notice provision. All members can participate by phone or video conference. You can be in different locations. You got to have one location that's open to the public, so everybody can be out of town. That's why we do most of our telephonic meetings, because our folks are not close enough to our office a lot of times to come in. You got to have somewhere open to the public. You got to tell the public where that place is. The notice requirement says that notice of telephonic meetings must be given 5 days in advance. There's some issues related to emergencies that you'd have to get with your lawyer about, but generally you do a 5-day notice. And so all of your members can call in from out coming in. They don't all have to be there. One of them can call in from being out. So one of them can be absent and still participate by phone. That's real useful where you might not have a quorum and you got to deal with something, so you get somebody in on the telephone. There are a couple technical things. If the person on the line service gets cut off for some reason, you're supposed to stop your meeting until you can get them back on the phone. That's to not leave them out of the loop. And make sure you have your notice and the public knows what. Y'all ever have anybody come to your meetings? Sometimes.
We often.
You have public come to your meetings, people who aren't on board.
Mainly the newspaper.
I mean, you got to have a place open for them to come listen. They need to be able to hear what's going on. You know, you can't put them in the back of the room and have a speakerphone way over there where they can't hear. They're entitled to hear what's going on. And then otherwise, you treat it, like a regular meeting. The votes are supposed to be taken by roll call vote. Y'all may do that already. I don't know.
That was something that came to our attention quite recently.
Yeah. So yeah, the votes are supposed to be taken by roll call, which I think roll call is you call out somebody's name and they say how they vote, and that's my reading of roll call. That's what the statute says. You got to record it, audio recorder. You got to record it, and you got to keep a copy of the audio recording for 3 years. If you're doing a video conference, I don't know if any of y'all do video. You can do video conference too. It doesn't have to just be telephone. It could be a video conference. You've got to record it with video if you do a video conference. So you've got to keep a recording of it for 3 years. And if you don't,
So simply the fact that it's not everyone in a room. So are you saying that if anyone is participating by phone, it has to be on phone?
absolutely.
Okay.
And I can't tell you the wisdom of the legislature that required that, but that's what the legislature requires.
The other thing we did is, he wanted to call in from vacation, but we hadn't noticed it the 5 days before, so we said, I'm sorry, we can't do the audio call, so.
And you probably need to get with your attorney and make sure that's right, but the law says you have to give a 5-day notice.
Yeah, but you got 12 months. Sorry.
No, that's fine. And that's why we need to cover it. My travel schedule in the spring seems to always fall on planning commission. And so there was one of them, I knew I was gonna be gone, and it was a pretty intense meeting, so I was gonna call in.
Are all of your meetings special call meetings?
No, they have.
Regular
actually,
meetings?
One thing that we never came back to that I may or may not have mentioned to Andrea was you can have a policy.
Yeah.
There can be a written policy in place that says members may call in. And the AG has said that is notice to the public.
Yeah.
More than 5 days in advance of every regularly scheduled meeting.
And I would suggest you get with your lawyer if you want to develop a policy, you develop a policy that complies with that Attorney General opinion. And basically what that Attorney General opinion says, any of our meetings that we call might end up being telephonic meetings, so you're put on notice from here on out. And the Attorney General said that complies with the 5-day notice as long as your meeting is otherwise properly noticed. So you don't have to jump to an extra hoop of noticing your
Every
meeting.
time, as long as you put that policy in place.
You gotta have a policy that complies. I would say get with your lawyer and make sure it reads right. And then you gotta also, whatever notice you provide for your meetings, it's gotta be properly noticed for whatever kind of meeting it is. But you don't necessarily have to do the 5-day extra hoop to go through if you do it that way. But yeah. Okay. Is that kind of what you wanted to cover on telephone?
Exactly. May not have been one of my.
All right, it's time. I mean, we're done, but, there's nothing else in here that's just so, I do want to say this, I do want to point out this, I didn't point this out at all. The first session, the Open Meetings Act says that you have got to provide an agenda and materials that will be distributed to members of the public. So you have to have a copy of your agenda and whatever materials your board members are gonna get, it's gotta be available for the public when they come to your meeting. I don't know if y'all do that, do y'all already do that? I'm still amazed at the folks who don't know about that. So make sure you have an extra copy of your agenda and your materials. And sometimes your materials can be kind of thick.
A lot of ours do, but we send out listserv agenda notifications.
Yeah.
And everything's, there are links to everything.
Do y'all send that out to the public too?
Yeah, anybody
Yeah.
who signed up for the.
Oh, great, okay. Well, y'all got to take care of it.
Could we put the 5-day notice about the telephone on the agenda?
I think you need to get with Paul and make sure that you get it done the way he would recommend. I don't have the opinion memorized. I know we have a policy and we've adopted a policy that complies, and I don't remember what it says, but I would want it to mirror what the Attorney General has already opined on. I don't recall exactly how that policy gets set up. I get to cop out on that and say, Paul, set that up for you. Okay, any other questions? Thank y'all for your time. Look, we're here as a resource for you guys, and I didn't go through this to start with. We exist not to just come in after somebody's made a mistake and, embarrass y'all, but we exist to try to help you guys out. And I've got my contact information in here somewhere. If I could get to it.
Add slides since this one.
There it is.
No, I had all those this morning too. We give out informal advice all the time, okay? We have a small staff, but we exist to serve as a resource to you folks. Y'all, we don't expect that y'all should have to know all of this stuff, but if you've ever got any kind of question, if you think you might have a question, please call us. I'm Chris. If you just call and ask to talk to one of the guys that answers questions down there, you'll probably get me or one other person. There are 2 people who take all of our calls. And any kind of question you ever have, we answer hypothetical questions all the time. I tell you, we're not like the auditor's office. We won't show up just because you called and asked us a question, but we're very interested in hearing from you all and trying to help you all comply with the law. Y'all got a lot of laws to comply with, and I know this is just like a little bitty piece of what y'all have to. You start talking about advertising requirements, and it gets kind of complex and tedious. But we're here to help you guys with the 3 areas that we deal with, and if we can't help you, we'll try to get you to the right person. So please don't ever hesitate to call us. Okay, thank y'all for your time. Appreciate y'all coming.